All right, we're in Chapter 9, Legal Writing, Form, and Substance. And paralegals do a lot of writing for their attorneys. And so it's imperative that you know how to write a good letter, know how to write a good memorandum, which we'll get into in LEX 120, 121. We don't cover that in this class. It's a little more advanced because it involves research and writing, but we're going to get into drafting legal correspondence. I have some of the lecture notes posted on Blackboard already, but I want you to read the pages. You can stop when it gets to legal memorandum. I don't remember where that one is, but you can read it for your own edification if you want, but we really don't need to go over it in this class. The moment your attorney gives you an assignment, a writing assignment of any kind, but especially a letter, you need to understand what he or she is telling you to do. If you have any questions about the assignment or the delegated task, I guess when you're in a law office, ask questions then. Don't be embarrassed. Lawyers talk a different language. And so if you don't understand the assignment, ask. In college, you're supposed to do that too. The reason is the law firm charges for your time. And if you go down the wrong path, doing not what he asks to do, then you're going to waste time and you can't bill the client. So it's imperative you understand the assignment. And I call that active listening. When the attorney or when you're speaking to anybody, interviewing a client, tells you something, you immediately say, okay, I understand you want me to write a demand letter to windows.com regarding the contract between our client and them. Is that correct? Give it back to him and say, no, that's not what I want you to do. I want you to write whatever. Or yes, that's exactly what I want you to do. There's deadlines in the law, just as there are in college. So you need to know when he needs it by, and don't put it off to the last minute. If he says, I don't need this for 2 days, go ahead and start now. Because law offices are very busy and emergencies come up every day. And if you put something off, you're going to be late. You want to get it in early. I always marked my calendar for a day earlier than I was asked to do something when I was an associate attorney. So when you're working on something also, if you wait to the last minute, they come in with an emergency and say, you've got to get this memo, motion, whatever, over to the courthouse right now. Please tap it up and get over there. You got to stop everything you're doing, close that folder, never keep more than one folder open on your desk, put that to the side and do what he's asked you to do right now. On page 244 in your book, it talks about a writing approach. Sometimes we just send informational letters. Sometimes we want to draft persuasive memorandums to persuade the court that our position is right. So you have to know whether you're just sending out information, instructions for the client to do something, or you're trying to persuade them to believe our side is correct. Okay. There are many tools for writing, and your book gets into that, and you can read about that if you want to. I'm not going to lecture on it. I do, and if I haven't pointed this out before, the book on page 245 says the blue book for citation, and you got to learn citation. A uniform system of citation is the Blue Book. It's blue. First put out by Harvard Law School. And the book also talks about the ALWD, the Association of Legal Writing Directors. We don't use that. Other states do, but we use the Blue Book in North Carolina. Right. You want to either have a law dictionary, which I don't think you need anymore because everything's on the website, but the most famous one is Black's Law Dictionary. When you don't know a word, you don't just skip over it like a layperson would. You go look it up. But you can research that online, and you don't really have to have, oh, I opened it to paralegal. So yeah, you need some tools for writing, and your law firm will probably have those. Okay. All right. You have to know if you're drafting a letter, which that's what you're going to be doing in this chapter. What's your audience? Is your audience a layperson, your client, or is it an opposing attorney? Is it the court? So you have to gear your writing to your audience. So you would write one way to your client without using legal jargon. You'd explain it in simple terms. Lawyers used to get paid by the word, I think, but we don't get paid by the word. So you need to be concise, simple. If you're drafting for a judge, then you're going to, of course, use legal terms and a different type of style. All right. It's going to get into writing effective sentences, active, not passive, and y'all just read that on your own. What I want to do, you'll also probably be writing pleadings, discovery, and motions. Those are all for the court and the opposing attorney. And we have forms for those. So templates. And of course you have to modify it to fit your situation, but start with a template. There are all kinds of books down in our library and at the legal library downtown that have forms, pleadings, motions, and you just have to change them when the facts are different. Insert your facts. So if you can find a template, lawyers hate reinventing the wheel, and so you use the template. It's not cheating, it's being smart, because those forms have been tried and true in the courtroom or with judges, and so you want to use what's already been written out for you. What we're going to be focusing on page 252 is general legal correspondence. General legal correspondence. And we have three main categories of, sometimes I call them letters, but they're correspondence. Informational letters, letters that simply provide information, and those are basically what we're going to write and use in this chapter, this assignment. Then we have opinion letters. Opinion letters provide answers to legal questions. A client comes in and was injured at Walmart, slipped and fell on something, and wants to know an opinion as to whether or not they can sue. Paralegals can write opinion letters, but they can't sign opinion letters. And why is that? Anybody?
Because we're not lawyers.
There you go. And it's the practice of law to give an opinion when you apply a set of facts to the rules of law. So when you write an opinion letter, for your attorney, and we don't sign these, so don't bother writing in your name and all that. These are always being written for your supervising attorney to look at and sign. So you don't play law office. It's just a draft. They can only be signed by an attorney, opinion letters, and therefore the signature line is for the attorney. And we're going to go through the parts of the letter. What you have to do, though, is we're going to do reference initials, and I'll show you how to do that. It means that he signs it, but your reference initials are there that you typed it. Okay. Then demand letters. Demand letters simply demand an action. They're usually written to opposing counsel or the other party to the lawsuit if they don't have an attorney, and they too are generally only signed by an attorney. Okay. I'm going to put up my example, but on page 254 there is an example of a letter, and you can look at that. That one's in full block. We're going to talk about full block and modified block. But this one kind of bothered me because it's rather terse due to the fact that the attorney is sending a letter from one attorney to the opposing attorney. But it's okay. We usually don't do that. We can be firm, and we certainly, when we are writing to our clients, we don't scold or demand anything. We write in a pleasant style, brief and to the point. All right, so I'm going to go over the sections of the letter. So I get to throw this over here. Go to share screen. Hey, coursework. I was listening to this lecture this morning, and it's pretty good too. So you might want to look at that. All right. Here we go. All right. So the one in your book is block format, and you can see everything's lined up in the margin to the left. This is a modified block, which means the first line is indented and the rest is lined up against the left-hand margin. You'll learn what your attorney wants, and you'll do what your attorney wants, but you do need to know the different types, block and modified block. In the assignment, there's always letterhead on your law firm letterhead papers, but I'm not going to be too worried about this in the assignments, but you do have to have a letterhead. And then we have to do all kinds of other rules to make it crazier for you. In a professional letter, legal correspondence, there's 3 lines down from the letterhead, and you give the date. You never abbreviate the date. You never say 5/24/12. You always write it out. It can be placed here, 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 wherever you want. The reason a date is important is why. Why is a date important in a letter in legal writings? Anyone? Because, oh, go ahead. Good, good, good. I didn't see your hand come up.
Good. I'm sorry. I didn't raise my hand. I'm just speaking out.
Okay.
A date,
go ahead, Lynn.
A date is important in a letter to document when you're communicating. And especially if there are deadlines in the letter, you have to send the deadlines ahead of the letter has to be dated ahead of in order to be
Yes.
fair, really.
Exactly, exactly. And I'll tell you what, there's a lot of times when the one important document you send is not dated, and that would be the critical one that changed the outcome of the case. So you date everything. I date everything, even my grocery shopping lists. I date everything. So 5 points there, Miss Lynn. Thank you.
Mhm.
All right. So the date, very important, always written out. Because if you put a number, sometimes you'll put the wrong number. It might be November and you put 10 and it was October. So you got to write it out. The next line is called the special notation. Special notation, method of delivery. Now, we only use a special notation when it's sent other than regular mail. So if it's sent regular mail, there won't be anything there. If it's sent FedEx, if it's sent via email, any other way, you put it. Right? Regular mail, nothing. Then 2 lines. And this is called the inside address. Inside address. And it usually goes in a window envelope. And so you want to not have any spaces between the various lines. Okay. This is the reference line. Reference line. In your book, it has capital R, capital E. I don't care. I've just all my life done it RE, lowercase, but whatever. There's a colon, and you just give them a little reference. They also call it a subject notation sometimes, of what this letter is going to be about. This one happens to be a demand letter. 2 lines. This is the salutation, the greeting. And you never say, hey, Dr. Gauze, or you never say that. Just dear. Just give it that one. I put this punctuation in big because we don't use a comma in professional letters. Let's just make it real complicated for people. We use a colon. That distinguishes it from a different type of letter, and this is a legal letter. Again, 2 lines, modified block. If your attorney says, I only want modified block, you indent. This is the body of the letter. The body of the letter is where you say your piece as clearly as you can. We don't want to use a lot of words when you can use one. We try to simplify our writing. My firm has been retained by Reed Dental Lab. Identify your client to collect an account from you in the amount of $2,000, and you always write the decimal point. And generally, you also write it out like this, depending on what your attorney wants. Just like you write a check, you've got it written on the line, and then you've got the amount in that little box on your check. We understand that the amount stated is the true and correct balance due and owing to our client. Enclosed, please find a copy of the original invoice for your reference. It's very important whenever you are enclosing a document or check or whatever, you make reference to it in the body of the letter. And we also notate it at the bottom. But whatever you are enclosing, you must tell them it's enclosed. If you have made any payment reducing the amount stated, please advise the amount you paid, to whom you made the payment, and when the payment was made. It is our desire to give you an opportunity to resolve this claim before legal action becomes necessary. If this account is not disputed, send your payment for the balance due to our office immediately. If payment is not received and legal action becomes necessary, appropriate measures will be taken to recover not only an amount due, but also court costs, interest, and attorney's fees if applicable. It is important that this claim be paid or we receive apply from you in connection with this account immediately. Otherwise, we will assume you do not wish to resolve this matter amicably. All right. Then we have a signature block. I always use verily, truly yours. Doesn't matter what you guys use, whatever your attorney says or whatever you feel like doing. But then you have to leave 4 lines. Type the name of the attorney, because this is a demand letter. Okay. So they can have space to sign their name. Some lawyers write big, some write small, but the proper method is 4 lines. Then after that, we have reference initials, enclosures, and copies. Reference initials are when the paralegal has typed the document for the attorney. And they are simply, this was signed by Susan E. Clark, so SEC / and then your initials in lowercase. I don't know why attorneys are uppercase and paralegals are lowercase, or secretaries are lowercase, but that's what it is. And then we've already made reference to the enclosure, what's going to be enclosed up here. So we come down here and we write out enclosure, ENCL, period, invoice. I think the ones in the book, I don't remember where it was. Yeah, on page 258, spells out enclosure and doesn't say what's enclosed. And that really bothers me. And I've already written the author many years ago and they didn't change it. But what the thing is, if you just put enclosure, the person's going to go, well, wait, what's enclosed? You have said it, but let's go ahead and tell them again down here. So you know when you're putting the letter together, you have enclosed the invoice. If there's going to be more than one enclosure, you're going to have an S, you're going to have invoice, and maybe, I don't know, set of interrogatories, whatever. So if you have more than one, it's ENCLS. Okay. All right. This is who you're carbon copying. You're sending it to our client, Reed Dental Ceramics, Inc. That's fine to have that there and let Dr. Gauze know that they've sent the letter to the client, also a copy to that. And then there's something called a blind carbon copy. Blind carbon copy, you don't put on the original letter because you don't want this person knowing you've sent a blind carbon copy to somebody else. What you do is, after you type up the letter, attorney signs it, getting ready to go out, you make a copy of it, and you put a blind carbon copy in the file. I'm sorry, you put a blind carbon copy to whoever else you're sending it to. And then you put the copy in the file. Blind carbon copy. Who else are you sending it to that you don't want Dr. Gauze to know you sent it to? All right. Questions? All right. Let's see what else. All right. All right. Did I go back to sharing me? Yeah. Okay. All right. So the informative letters simply inform the other party about something. If you're sending it to a client and you say, is there anybody still here? Oh, how come it only says 1? There we go. Sorry. Informative letters, you're just sending something to a client, your next court date is, or I've received the papers you sent me. You're going to have a deposition, you're informing them about something. Confirmation letters are also important. They communicate certain information confirming something that's already happened. Client's number one complaint against the Bar Association is my attorney's not communicating with me. So you want to make sure they're kept up to date and informed. And it's so easy now, by email or whatever, and a lot of law firms do use emails. But that's the number one complaint. Opinion letters, or an advisory letter we've talked about just a little bit, is that giving an opinion of something, only drafted by, signed by attorneys. They have an example of an opinion letter, page 258. And you'll see that it's signed by the attorney, Alan P. Gilmore, and then the reference initials at the bottom are APG / and then the name of the paralegal or secretary. And that's the one that I don't like. They just say enclosure. They don't say anything else. Okay. Actually, that's a whole lecture. It's something you have to read if you've never written a letter. Your favorite closing is with best regards. Yeah, that's a good one too. I sometimes changed the closing to whatever the mood was in the letter. If it was a demand letter, you know, it's not a pleasure to talk to you or whatever. It's just please adhere to demand, whatever. But whatever the tone of the letter is, whatever you like. You're not writing it to your grandmother. You're writing it to someone else. But I like that one too that you had. Okay. And we stop it at the memorandum. So that's page 260. So not a whole lot to read. I guess I could go back and show what the assignments are. No, I can't. I don't know what I've done wrong. But you do have some assignments, but they're not due for a long time, I think. Don't pay any attention to me. I'm going to stop recording.